future. Thank you, Madam Speaker.
Resuming debate, reprise de débat, l'honorable député de Mont-Royal.
Merci beaucoup, Madame la Présidente, et c'est un grand honneur de me lever aujourd'hui dans la Chambre pour parler des modifications sur la loi sur la participation publique au capital d'Air Canada. C'est une proposition de loi, Madame la Présidente, qui est très courte et j'imagine pas controversée dans plusieurs aspects. En termes du fait qu'on change la ville de Mississauga, la région, le CUM et la ville de Winnipeg aux provinces du Québec, provinces d'Ontario et provinces de Manitoba, j'imagine que ce ne sont pas des changements controversés. J'imagine le fait that we're updating the definition of what constitutes maintenance to say maintenance is not controversial. What I do hear from the opposition, and I understand that, is a concern about jobs. It's a concern about the fact that the law will allow more flexibility to Air Canada and doesn't require that all of their maintenance be done in Montreal, in Mississauga or Winnipeg, or even in those provinces. It gives flexibility to Air Canada to decide where it may locate workers, provided that it retains centers of excellence in those three provinces. So I can understand, I hear the NDP, I understand from the perspective of unions, they're nervous, they're worried that jobs may be lost because they no longer have the same legal protections they had before. So I get that. And I listened to the Conservatives and I heard the argument that Air Canada, originally in the late 1980s, when it was privatized, had received from the Canadian taxpayers a certain amount of equipment and landing rights and other things that mean that Air Canada had certain obligations that shouldn't be imposed on other airlines, and I understand that as well. So let me explain, Madame la Présidente, why I do believe that this amendment to the Act actually does make sense. First, let me start off from the perspective, as a Montrealer, that I'm very happy que la siège sociale d'Air Canada doit rester à Montréal. Et on exige encore tous les règlements sur le bilinguisme qui existaient avant. But on the other hand, Air Canada is a company in a market that has changed very significantly since the 1980s. In the 1980s, there were far fewer airlines. Today, those of us who, before we came into this House, had a lot of business travel that we needed to do, know there's low-cost carriers domestically and abroad. There's carriers from the Far East and the Gulf states that now have taken over a lot of the international routes. Our American companies in aeronautics have merged and been restructured. Almost every one of them has passed through bankruptcy protection. And even in Air Canada, Madam Speaker, has gone through the Canadian Creditors and Arrangement Act 10 years ago. Air Canada is not the healthiest financial company that there is. And we all understand that, and the success of a very strong domestic airline like Air Canada, and it's good that we have other domestic airlines as well, like WestJet and Porter, is a prerequisite for the Canadian economy to be successful, because Air Canada employs not just 2,600 people in maintenance, but 26,000 people across Canada. So Air Canada does need, now that it is a privatized company, to have the ability to move jobs sometimes. It's clear, I was in private industry. Before I got here, I was the general counsel of a multinational. And while we always wanted to keep jobs in our major centers, it is important to have flexibility, because companies owe debt. There are shareholders of those companies, and there is a need to success. We don't want to, as a government, be told that we will need to put another $1 billion into Air Canada to keep Air Canada afloat one day, or $2 billion, or $5 billion. So we really do need to look at what Air Canada needs to do. I'd look at it from this perspective. Yes, there were assets, because I think the main argument, and I'd like to try to hopefully convince my Conservative counterparts of this, there were obligations that were given in the late 1980s based on the Canadian taxpayers having helped set up Air Canada. But every one of the assets that Air Canada would have received in 1989, the amortization period would long since have ended. The usefulness of those assets would be hardly the same today as they were in the late 1980s. So not only has the market changed, But the situation has changed. We're 27 years after this law was first adopted. And so it is true that we put obligations in the law in the late 1980s. But now, Air Canada may well need to compete more flexibility. Let me also say that when I talk about flexibility, because this was the case in our company, I'm not talking necessarily about moving jobs out of the domestic market. We would be looking at whether or not all of our jobs should be in Montreal, or should we put jobs in Toronto, in Vancouver, in Winnipeg, in Halifax? Why are there only 3 provinces in the country where Air Canada can locate these jobs? Why can't Air Canada say it is more competitive? There is a company in Vancouver, or there's a company in Edmonton. The Alberta economy is suffering. There is a company in Edmonton that can do this work cheaper and better than the companies that we're outsourcing to in another city that's covered under the law. Why can't Air Canada decide to move jobs there when every one of its competitors can make that rational decision? Personally, I understand the need to protect Canadian jobs, but all of our other air carriers that are domestic carriers in Canada don't have the same limitations as Air Canada. And as I hope I've successfully explained, the historical context is not as relevant today as it was in 1989 when this law was adopted, because the assets we provided, the landing rates we provided, everything has depreciated since then. So let's then go back to the issue of what this allows Air Canada to do. We had the litigation with Avios in 2012, and Quebec commenced litigation and won at both the courts of first and second instances with respect to the fact that Air Canada had an obligation legally to keep jobs in Montreal. And there were discussions, Madam Speaker, discussions with the Quebec government, discussions with the government of Manitoba. I assume the federal government at the time and continually was kept up to date and in the loop on those discussions. And there seems to have been, and none of us in this room, or I don't know of any of us in this room, that were sitting at the table, that on these settlement discussions that probably went on for a very long time, we've had a conclusion where there have been promises made. There's been a contract given to Bombardier. There's been a commitment to the government of Quebec that the Bombardier aircraft will be maintained in Quebec for the next 20 years after delivery. There's been an agreement in Manitoba that there will be a center of excellence in the city of Winnipeg that will employ and hire a new 150 people. So Air Canada does indeed seem committed and has actually negotiated settlements with governments of these jurisdictions to, at least to the satisfaction of those governments, keep jobs in their respective provinces and agree to drop the suit. At that point, the federal government also needs to look at what's been negotiated when we weren't necessarily right at the table, but we probably have been kept in the loop. And we need to say, okay, the Quebec government, the Manitoba government are satisfied with these changes. Air Canada has said as a prerequisite, probably of doing these buys and making these commitments, we need more autonomy. We need to be able to compete. And the federal government is acting to allow that. Now, Mr. Speaker, again, am I sorry for the people who may be worried that as a result of these changes, their jobs may be more at risk? Yes, Mr. Speaker, I am. And I think this government is committed in the budget to do more to enhance technology in Canada, to enhance aeronautics in Canada, to invest in middle-class jobs. But, Mr. Speaker, am I panicked about this? No, I'm not. Because these are not jobs making widgets that can be easily exported to China or India. These are highly skilled mechanics doing work on specific aircraft owned by Air Canada. In my view, Canadians and Canadian workers who are highly skilled, highly trained, are able to convince any company to keep jobs domestically. That is my feeling. I feel that our workers in Montreal and Winnipeg and Toronto and across the country will be able to convince Air Canada that they can do the job more effectively and more cost effectively than relocating those jobs abroad. So where I understand the concerns, I acknowledge the concerns. I'm not going to stand up here and say there are no concerns. I do believe that this law is, the amendment to the law is correct, and I'm proud to support it. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The honourable member for South Surrey, White Rock.
Speaker, as the member laid out in his eloquent speech, there were significant taxpayers' concessions that were given at the time of the agreement. But I also recall the Prime Minister sitting here just not 2 days ago saying a deal is a deal is a deal as it related to the Saudi arms deal. I'm wondering why doesn't it apply to this?
L'honorable député de Mont-Royal.
I'd like to thank my honourable colleague from Surrey for her question. I think the answer is what the Prime Minister was speaking of was a deal with a foreign country where Canada's reputation abroad is at issue. This was not, we're talking now about amending a law. There was no signed agreement related to the federal government adopting a law. These were terms laid out by the federal government at the time. We're not breaching a contract. We're going back to the Parliament of Canada and asking the Parliament of Canada to legally amend a law. So I really don't see that there is the same issue there. Thank you, but thank you for the question.
L'honorable, resuming debate, questions and comments, questions et commentaires. L'honorable député de Sherbrooke.
Merci, Madame la Présidente, et je remercie aussi mon collègue pour son discours. Et je me demandais, parce que c'est assez surprenant de voir les libéraux avec un discours comme celui-là, alors que dans le passé, le discours était totalement différent. Dans le passé, même, je me souviens très bien d'avoir vu le premier ministre actuel sur les marches du Parlement avec son microphone et en scandant des beaux slogans pour appuyer les travailleurs, puis réclamer aussi que la loi soit appliquée et que la loi, en fait, que les emplois soient conservés pour sa part. Je pense qu'il était surtout concerné par les emplois à Montréal, comme mon collègue doit l'être également. Et donc, je me demande qu'est-ce qui a changé depuis ce temps-là, depuis quelques années, même, ça fait pas si longtemps que ça, entre le temps où les libéraux réclamaient que la loi soit appliquée et qu'on respecte les travailleurs d'AVEOS. Et là, aujourd'hui, on dit, les lois du marché, les forces du marché vont permettre à Air Canada de décider où ils vont avoir leur emploi. Et ça ne les empêchera pas de les délocaliser à l'extérieur du Canada. Alors pourquoi ne pas avoir au moins assuré que les emplois vont rester au Canada si mon collègue est si concerné par le fait que les 3 villes soient trop contraignantes? Pourquoi ne pas avoir au moins statué que les emplois doivent être au Canada?
L'honorable député de Mont-Royal.
Merci, Madame la Présidente, et je remercie mon collègue de Sherbrooke pour la question. Et je crois que ça, c'est exactement la raison qu'on devrait appuyer cette loi pour aller au comité. Et au comité, vous et votre parti peuvent proposer un amendement comme ça. Pour moi, je suis très satisfait que l'atmosphère a changé depuis 2012 à cause du fait qu'il y avait un règlement au litige. Et le règlement de litige a protégé plusieurs jobs à Montréal parce que là, il y aura un grand achat de bombardiers et il y a un contrat qui maintenant va être signé qui dit que Air Canada va garder des emplois à Montréal pour 20 ans après la livraison de ces avions. Merci.
Questions et commentaires. Questions and comments. L'honorable député de Laurentide-Labelle. C'est bien ça?
Thank you, Madam Speaker. The existing rules require that maintenance be performed in the Montreal urban community. Now, the Montreal urban community hasn't existed in 15 years, or about 3 prime ministers. I'd like the member to speak a little bit about why it's important to modernize the laws and bring them up to date. Thank you, Madam Speaker.
L'honorable député de Mont-Royal.
Thank you very much to my colleague from Laurentide-Labelle. Well, I think that is true. Having been a mayor in the region of Montreal, since the forced mergers of 2001, the MUC has not existed in that name, and so technically we would certainly want to amend the law for that reason. But as I mentioned in my speech, I do believe that the situation has changed in 27 years. What happened 27 years ago was the state was giving assets and privatizing a company. And as a result, the state felt that it was incumbent upon it and reasonable to impose limitations on that company. Some of them remain in effect, such as the need to keep a head office in Montreal, such as the requirement of Air Canada to provide services in English and French across the country. But some of them, due to the changes in the industry and changes in Air Canada, which went through CCAA proceedings not 10 years ago and was losing money until 2011, may need to be made, and I think the government is modernizing the law to make them. Thank you.
Resuming debate.